term sentence is an argument for, but let me begin with the improper conviction for unlawful restraint. This issue turns on a single distinction. Being locked out of the house is not the same as being detained in a shed. Count 2 did not charge that Jeffrey locked LP out of the house. It charged him with detaining her, quote, by forcing her to sleep in the shed. And detention has a specific meaning. It's conduct that keeps a person from moving from one place to another. That's Bowen. And under Kuykendall, the state has to prove that the conduct actually caused the detention. So here's the problem for the state. Its own evidence showed that the shed was unlocked. Defense counsel asked directly on cross, did he lock the entry and exit ways to the shed? No. Any of them? No. She confirmed it again in a rebuttal. What Jeffrey locked was the house, but he isn't charged with locking the house. He's charged with detaining in the shed by making her sleep there. The state never proved she couldn't leave the shed. And frankly, the charging document is circular in its reasoning. It says, in effect, that he detained her in the shed by forcing her to sleep in the shed, but it doesn't explain or later prove any mechanism for how she was forced to stay there. Now, the state's only claim for detention is that she was afraid, based on their history and the children being in the house and so on. But that general fear alone is not detention unless it's coupled with a clearly expressed threat. That's what we have in McWilliams. Look
Mr.
at
Waller,
the threat. Yes,
I want to back up to something you said earlier, though, which is the state can't prove detention, just simply that she was locked out of the house. It was more than that, though. He sent her out, defendant sent her to the shed. He didn't just send her out the door and say, you're not coming back in. He sent her out to the shed, right?
Yes, that appears to be the case.
And he did it as punishment. Isn't that what the testimony was?
That was her testimony, yes.
Okay. And then victim indicated that she couldn't come back into the house until he came out to the shed and told her that she could come back into the house. Isn't that right?
Yes, Your Honor, but the word couldn't there is doing a lot of heavy lifting, because the state has to prove is what that mechanism of couldn't was.
Well, can't the jury draw inferences from evidence, including the language couldn't?
Well, they'd be drawing inference of an entire element that was not supplied, because there has to be a threat. There has to be either the thing that detains her, handcuffs, a locked door, or there has to be a threat. Move and I'll shoot is the kind of thing we had in McWilliams. There has to be a specific threat, not just a general fear. An abusive relationship doesn't convert every command, order, request into unlawful restraint for fear of an unexpressed thing that might happen if it's disobeyed. She proves this herself about being able to. It comes down to whether she can leave, and she says, I had the keys. That's not the issue.
Mr. Waller, yes, let me cut in. I feel like we're jumping ahead here. The question from Justice Harris seemed to be with regard to the punishment and the parameters of that punishment and when she could be released from the shed, things of that nature. So I believe the question was, is she was to stay in the shed according to the understanding of the punishment until told she could come out. Do you want to answer it?
Yes, Your Honor. Again, the mechanism that forced her to be there is never proven or expressed. There's no threat directly tied to if she leaves.
But the question is, what were the parameters of the punishment? I mean, it's a simple question. And
well, I don't think it's simply answered and expressed at trial. What the punishment would be, she never testifies to. If she leaves, and again, detention has to be
not the punishment. The parameters, meaning she's told that there's an issue, it's time to go to the shed, and it's my understanding that you've agreed that the understanding was that she was to come out of the shed when the gentleman came out and told her it was time and she was allowed to leave the shed. That was to me, that was the question Justice Harris asked.
Yes, I agree that that's what the testimony was. Yes.
Thank you.
Yes, those were the parameters. Don't leave until I come back and get you. But what that does is that admits that she could leave. She's not physically kept from leaving. And there is no threat tied to her ability to leave. Because she could leave and be punished for it later, that means she wasn't detained simply because a consequence could follow. It's not the same immediate detention as for move and I'll shoot. McWilliams is an outlier in that way. And I think that
you also referenced Bowen, and Bowen stands for the proposition that the restraint is due to the lack or the inability to have freedom of locomotion. And so with that understanding, no clothes, under a threat of further punishment, children in the house. You want to address that concern for locomotion, leaving, escaping, so to speak?
Yes, Your Honor. Under all of the things you've described, her locomotion was not impaired.
You
She
don't
could
find you
locomote.
don't find the idea of further punishment, absconding in the nude into the night and leaving the children in the house with this punisher to be strong motivation not to leave? Or at least
I don't.
let me, that's a
Sure.
tough, that's a loaded question. Can you just take in those factors and tell us how they work in your favor?
Because first of all, because she's allowed to now, she may be punished later, but she's allowed to leave, and that's what unlawful restraint prohibits. If she's allowed to leave and be punished later, and again, the key here is that any possible punishment is largely implicit. It's not testified to. There's no action he takes that's tied to her leaving. There's her belief that she will be punished. The threat he makes about killing anyone who comes between him and the relationship, him and the children, is a threat about leaving the relationship, but not about leaving the shed. And again, because she can't testify to any particular threat or any particular restraint that was laid on her, there was no unlawful restraint.
But the language in Bowen speaks of impairment. Locomotion is impaired. So again, my concern is you've got concern for the children. You're in no state to be running around town, arguably, and there's fear of further reprisals. Wouldn't that be an indication of any type of impairment to just up and leave the situation?
Not to rise to the level of felony unlawful restraint. And unlawful restraint contemplates a more direct restraint, because unfortunately that would be an extension of the law that would swallow every abusive relationship. Every abusive relationship would, where you can't go there without me, you can't go unless I drive you there. Take the kids here, don't take the kids here. Every order an abuser gives would be an impairment on locomotion.
Well, every
It would
case
be.
stands on its own facts, right? And then we apply the law.
You're right, Your Honor. And under just about every domestic case I've ever seen, there would be an element of unlawful restraint, and that's not what's contemplated by the statute. One of the things that, by definition of abuse, is restraining people's locomotion, or setting conditions upon it or punishments for acting on it. And that's simply not what unlawful restraint or false arrest, its predecessor, contemplated. So those things are outside of the bounds of it. If the court reverses on count 2, resentencing should follow. Under Maggette and Alejos and Figures, if we do vacate count 2, if we are 100% sure that the sentence would be the same, then we don't need to send back for resentencing. But there is one statement that the court made in this case that I think raises it up for a question and should give the trial court another opportunity to resentence without count 2, is when the court calculated that the range is 15 to 72 years. Even though count 2 is sentenced separately, because it was kind of factored into that whole range, we'd like the circuit court to take another stab at this, just in case they knew more than we think they did about how to structure that sentence based on that. Now, that takes us to the second issue.
And before you get there, Mr. Waller, go ahead, Justice
No,
Landers.
go ahead, Justice Harris. Go ahead.
Well, I was just going to say, before you get to the second issue, there's kind of a segue here, which is the evidence that you're going to discuss in issue 2. That'd be the kicking with the boots and the whipping. That if that was before the jury as evidence, why wouldn't that be sufficient to support the conviction for detention in terms of the threat of physical harm, if the victim had previously suffered that type of harm at the hands of the defendant?
Well, I think that this certainly does highlight the prejudice that is derived from issue 2. Certainly, this poisons every other remaining count.
Well, and you'll get to that when
I'll
you
get to
talk
that.
about
But to answer your
issue
question,
2.
I apologize. Yeah, to get right to your question, because it's not specifically tied, just because bad things had happened in the past. It's not a specific of enough impairment. It's not a specific enough threat of a response to a particular action that qualifies that it's the same as a handcuff, that's the same as a locked door, because that's what unlawful restraint contemplates. So if we're going to choose words that are as strong as a handcuff, they need to be express, and they need to be clear. And we don't have that. We have a general fear based on things that have been bad in the past. And I don't think that converts every single command anybody gets in an abusive relationship to unlawful restraint. Or if
So
it
the
does,
only
I
way
think Congress should
defendant could
speak
be
to that.
convicted of detention, unlawful restraint here, is if he had followed up his command that she go to the shed as punishment with the threat of physically harming her. If you leave that shed, I will kick you or whip you.
Or locking the shed. If he wanted her to stay in the shed, lock the shed.
Well,
That would be unlawful restraint, or a threat as expressed as you just vocalized, Your Honor. Yes.
okay, go
Uh,
ahead.
to rise to this level. Anyway, that brings us to the second issue, that counsel was ineffective for not moving to dismiss counts 9 and 10. And I want to start with what's not in dispute. The state has conceded counsel's performance was deficient. No reasonable lawyer would have let time-barred misdemeanor charges, especially violent ones, go to trial without moving to dismiss them. So they're plainly barred. The only question is prejudice. The harm here is that what that evidence of those improper charges did to the trial of everything else. Let's talk about what happened in front of the jury. They were told in opening statements that they were going to hear about 11 different criminal charges. 2 of them were time-barred counts. And the state proved those time bar counts vividly. The jury heard that he kicked her with big construction boots over and over, leaving marks on her legs, her back, her buttocks. It heard that he whipped her with a car hose. And the jury didn't just see it. They didn't just hear about it. They saw it. The state published photograph after photograph of those injuries and walked the witness through all of them. There were more photographs devoted to those 2 misdemeanor counts than any other particular charge. It was
Why
the most
wouldn't
graphic.
this evidence have come in anyway? The
Well,
state,
the
state
state
suggests that section 115-7.4 would have allowed for its admission.
Sure. The 115-7.4 may have allowed for its admission, could have, but all that evidence still would be subject to probity and prejudice balancing, which is a lot harder for other crimes evidence than it is for evidence of a charged offense. The probity is by necessity lower. And so the court is required to exercise discretion, not only on whether this comes in at all, but the nature and manner of the proof. Make sure, because things are going to be a lot more cumulative, a lot quicker when we're not even talking about a charged offense.
In your brief, did you argue that it was either irrelevant or that its prejudicial effect substantially outweighed its probative value? I know you quoted or you referred to People v. Dabbs, that is the gatekeeping function of the court. But specifically in this case, as to those 2 aspects, did you argue that evidence of the kicking or the whipping was irrelevant, or that its prejudicial effect substantially outweighed its probative value?
Well, we can't make that argument because the court didn't entertain arguments on that. Like, that isn't in the record, unfortunately, because the court was never given the opportunity to have a hearing on the probity. We know that the probity is less, certainly, than it is for a charged offense.
But
So,
to establish prejudice here in terms of ineffective assistance, you have to argue the prejudicial effect, right?
sure. And we'd argue that, first of all, well, let me walk through it. Lindgren and Mason say that improper admission of other crimes evidence ordinarily requires refusal on the others. By definition, it's that prejudicial. So there needs to be an exception. We know that the evidence was improperly admitted here because the court was never asked to exercise its discretion to allow this under 115-7.4. And an abdication of discretion, not even getting the chance to exercise discretion, is an abuse of discretion. So the evidence came in improperly, because nobody did a probity versus prejudice analysis for other crimes, which is a completely different analysis than does this evidence relevant enough for its own charges. So we know that it's improperly admitted. And when that is the case, the normal course of business under Lindgren is that reversal on the other counts is required. Mason.
Well, no, the improper admission of evidence doesn't standing alone require reversal. You still have to prove prejudice here when you're making an ineffective assistance claim. So how do you establish prejudice if you haven't argued either that it was irrelevant or that its probative value was substantially outweighed by its prejudicial effect? That's what I'm asking.
Sure. Well, Your Honor, but I would pick a quick nit with you on that one. Other crimes evidence it makes things more subject to reversal. That's not because it's so prejudicial, not just improperly admitted evidence, but improperly admitted other crimes evidence is more subject to admission in the ordinary course of things. That's the language from Lindgren, and then in Mason, this court reversed in Mason for the same reason, because other crimes evidence is special. So in this case, like I could have argued in the brief, we know that it was less relevant because it's not to a charged offense. We know that it's highly prejudicial because we've got more photographs of this event than any other event. But the problem is because the court was never asked to have a hearing on that, because everybody failed here. The court failed, the prosecutor certainly failed by bringing improper charges, and defense counsel, everybody here agreed it's failed. Because everybody failed, the court was never able to have arguments on that. So I think it would have been improper for me to come in and say, look, clearly de novo, this stuff shouldn't come in. The problem is it came in improperly. We know that, because the analysis was never done. And because of that, it's so prejudicial, it's likely to have poisoned the trial on the rest of the counts. Again, 115.7.4 is not a blank check. That you have to do the analysis. Strickland does not ask whether acquittal was certain. It asks whether our confidence in the verdict is undermined. And after the jury saw and heard all of this, page after page of photographs, all this testimony about this particular offense that they never should have heard or that they may not have heard, with no instructions to disregard it, with no limiting instruction. And again, if we'd had a hearing, the court may very well have limited the way some of this evidence come in, may not have allowed photograph after photograph, or may have given it a limiting instruction. But the way the jury got it, we cannot have full confidence that they convicted on every other crime. Again, specifically, as Your Honor just announced, this may have letting this in may have helped prove count 2. I don't think it does, but either way, that type of thinking is what we need to be aware of when all the other counts here are this type of domestic violence related. Very briefly, just a couple of points on the sentencing issues. On argument 3, the court used, as we know, the recorded interviews and letters from the children, which were in severed counts that the defense couldn't cross-examine, couldn't testify about. Those charges were all still pending. And the court admitted that defense counsel was handicapped. I would say completely handicapped. I would say it was non-adversarial at all on those counts, because there was no way that the defense could meaningfully participate in challenging the evidence while those charges were pending. And so because of that, the sentencing hearing fell below an objective standard of fairness that due process requires. So there's a due process violation for that. Lastly, excuse me, one moment, quick drink. Just briefly on the 4th issue, this was a benefit of the bargain issue. Primm gave up his right to challenge the sentence that was a predicate for extended terms because he thought he was getting a global disposition that got rid of extended terms. When that deal fell apart because he was improperly admonished, his attorney didn't file the motion to renew that 604D motion. And that hung around for a couple years later. And then when the court asked defense counsel, the onus is on you. Can you file something that says I can address this? Counsel filed nothing, raised no argument. So because the state was allowed to keep the benefit of the bargain with him not re-challenging the extended term eligibility, because he didn't challenge the improper conviction the first time around, the state shouldn't get the benefit of the bargain. The case should be remanded for a new trial on all counts, or at least for resentencing on any surviving counts. And those sentences should be capped at non-extended terms, just because the equities involved with the issue 4. If there's no other questions, I'll speak with you again in a moment.
Seeing none. Thank you, counsel.
Thank you.
Counsel Theopoli, your argument, please.
Thank you, Your Honors. May it please the court and counsel. Just to start with the one that defense attorney just talked about, the last issue. Defendant had a pending challenge one time to his plea of guilty in 15 CF 1858. I'll just say that's the other case for simplicity. I think his challenge was based on the idea that he was not admonished that those convictions could be used as extended term sentencing factors. for this current case. So that remained pending for a long time. Initially, the trial court told the defendant that he was not extended term eligible in this case, but then the next day corrected that with the defense attorney's agreement that he was in fact extended term eligible based on that previous case. So the trial court corrected that admonition. They proceeded to a negotiated plea of guilty, which he then was allowed to withdraw because apparently he was admonished about the offenses being mandatorily consecutive, which was incorrect. But this record doesn't show what sort of advice the defense attorney gave the defendant about the inability of the trial court to put him basically status quo ante upon withdrawing his plea. In other words, a competent defense attorney would have said, now look, this has been over 2 years since you dismissed the other case, this motion to withdraw a plea, and the trial court's not going to have any jurisdiction to reinstate it. So if you choose to proceed with trying to withdraw the plea in this case, then the trial court will be bound to make you extended term eligible based on your prior conviction in the other case, because as the defense attorney would say, I can't do anything. It's been 2 years and there's no jurisdiction. These convictions are years old now, and over 30 days have lapsed. You just can't file a new motion or reinstate a prior abandoned motion. So the trial court was unable to put him back to status quo ante. And that's something that the defendant should have realized. But if he was not making any sort of allegation, then that he was affirmatively misadvised by his attorney, for example, then if he could do that in a post-conviction case, then he could say in a post-conviction petition, my attorney affirmatively misadvised me. He told me that he could handle this and I would not be extended term eligible if I withdraw my plea of guilty in this case. But that's not in the record, so there's no basis to reverse the sentences on that ground in this appeal. The other thing is the possibility he could file a motion for supervisory order to say to the Supreme Court of Illinois, it's a situation where I had relied on this negotiated plea and I abandoned my challenge to the plea of guilty in the other case. And now, because of lack of jurisdiction, I'm unable to proceed with that challenge and protect myself from extended term sentencing in this case. Because of the lapse of jurisdiction, the trial court's unable to do anything about it, but Supreme Court of Illinois can correct that by a supervisory order. So there's a couple of mechanisms you would have, but reversing in this appeal is not available because the record doesn't support it. And the trial, I mean, he's saying the attorney failed by failing to file an untimely motion withdraw a guilty plea for which the trial court would have no jurisdiction to grant. So there's absolutely no prejudice possible from that sort of an argument because the trial court could not have granted an untimely motion withdraw a plea in the other case. So essentially that's where he's at. He's going to have to do this on one or two other ways, post-conviction or supervisory order. With respect to the idea of due process at sentencing, working backwards to the third argument, I think the defendants are believing that he has a right to cross-examine the children because they were the victims of the other counts that were severed. Due process at sentencing permits hearsay testimony. It's admissible. Here, the other crimes were properly proved up by testimony. Now, it wasn't the children's testimony. It was LP's testimony. It was an officer's testimony, and they were admitted by the videos of the interviews. But as long as the trial court finds this all relevant and reliable, and the trial court did and found there's no abuse of discretion in those determinations, and they are reliable. These interviews were corroborated by LP's personal knowledge. She saw the abuse. She saw them write their statements. She took photos of the children's injuries. So all this is corroborated, definitely relevant and reliable. So definitely admissible. And the idea that due process would somehow give him a right to require the children to testify at a sentencing hearing and have a right to cross-examine the children, that's not supported by any authority. So the cases dealing with like victim impact statements are distinguishable because this case did have testimony. Working backward again, with respect to the ineffective assistance claim for the failure to dismiss the battery offenses that were time barred, the defendant, I think, his initial argument was that a trial court, if the defense attorney had been competent, he would have filed a motion to bar these under speedy trial, and therefore the evidence would never reach the jury. That was his initial argument, and I cited section 115-7.4 and said, well, actually, if it was other crimes evidence, this is the type of case in which it would have been fully admissible for any purpose without limiting instruction, even for propensity. So This is distinguishable from other situations. And in fact, I think the defendant's own cited case, the prejudice was the fact that he received a conviction and sentence for something that should have been dismissed. I mean, that's not the prejudice here. These cases, these charges were actually dismissed. He's not been sentenced or convicted of them. I think he's trying to say that this other evidence shouldn't have come in, but yet, and also there's a lot of other domestic batteries in this case. So the idea that a couple more, I don't think would have made a difference, and especially in the light of the fact that LP's testimony about that the other offense is corroborated by many photographs. So he'd have to show that there's a reasonable probability that he would have been acquitted of the other crimes had this evidence not been allowed in, but yet the evidence is allowed in through 1157.4. So I think he'd have to show, first of all, that it wasn't admissible under 115-7.4. And that even if it wasn't admitted, that he still would, he'd have to show a reasonable probability he would have been acquitted without that evidence admitted at all. Or maybe, I think he was trying to say that also less evidence would have come in if it was other crimes instead of a charged offense. So if you take out a little bit of that evidence or some of that evidence, was there a reasonable probability he would have been acquitted of these other offenses? That's not something he's going to meet his burden on. With respect to the main issue, I think was this first issue. The unlawful restraint, the juror is entitled to use common sense, and appellate court looks at this from a standard of most favorable to the prosecution, and the juror is entitled to make reasonable inferences. So in an existing domestic violence relationship, when an offender who's already physically abusing a woman, sends her out to the shed naked and tells her she has to stay there as punishment, and she understands, I think the jury understands from common sense too, that he's going to get up frequently, as she's testified, and check on her potentially, and that she's not there, she's going to be subjected to what she said, quote, more severe punishment, which means the physical stuff. So to think this is not a lock case, she's not locked in the shed, that was never a point, that's a red herring. This is a case about threat. And I think the defendant's position is she was never threatened, or like the sense of not just pointing a gun, but actually saying the words, don't move or I'll shoot. I mean, the idea is, I think his point is, well, maybe the threat is a little more implicit than actually saying, don't move or I'll shoot. I mean, if somebody's pointing a gun at you and the implication is you're not allowed to move, that could be a threat that constitutes unlawful restraint. You don't actually necessarily, I don't know if he has a case that says you have to say something verbal, that you have to verbalize the threat. The threat, I mean, the fact is the idea that she's locked at the house, the kids are inside, and she's naked in the cold, and that she's set out there as punishment until he tells her that she's allowed to come back inside the house. The jury's common sense. This is detention. To say that there's any reasonable doubt as to whether this is detention or not, just the trial court had no problem with it. The jury had no problem with it. I don't see why this court should have any problem with calling that detention, because this is about as most of a severe of a situation involving someone who's not actually locked in a shed. And the only thing really lacking is the direct testimony as to an actual verbalized threat. But the circumstances are so overwhelming that was an actual threat, that she was forced to stay in that shed because he told her she had to do that under threat of more severe punishment. And that's something the jury was entitled to decide. And last question, I think, is, was there, if this court did agree and vacated that count, whether there would be resentencing required on other counts? I believe that the issue here would be, did the trial court actually rely on this unlawful restraint offense in aggravation of the other offenses? And I don't believe that's shown in the record. There's certainly no explicit recognition of this being an actual aggravating factor that enhanced the sentences of the other offenses. So the fact that these are sort of lumped together in a sort of generic range doesn't mean that they were actually relied on in aggravation. And so there's no real reason to, if this court vacated that conviction, to vacate the other sentences and send it all back. For that reason, the state would request this court to affirm the conviction and sentences. And unless you have any questions, I thank you, Your Honors.
Seeing no other questions, thank you, counsel. Mr. Waller, rebuttal.
Thank you. Just very briefly, as far as whether or not, again, I think it's important that the other crimes evidence is not a no-brainer to come in under 115-7.4. It's I don't think we have to, first of all, we don't have to demonstrate that it absolutely wouldn't be admitted. We have to show that our confidence in the outcome is impaired, that there's a reasonable chance that some of the other counts would not have been found guilty. The reason I'm less comfortable that those would have resulted in guilty verdicts is the state would have had an uphill fight on their hands to admit that evidence in the volume and manner in which it was admitted, with no limiting instruction whatsoever. It would not have. We know for sure that it wouldn't have come in the way it came in. The jury wouldn't have been possibly confused by being told they're going to hear about 11 offenses, but only asked to find guilt on 9. Their chance would have been less successful to get this evidence in as other crimes evidence, and the nature of it's so prejudicial that I think, again, the way the state just expressed, we heard a lot of domestic violence. What's 1 or 2 more? I think that's the real fear. If they shouldn't have been exposed to it, or if the state would have had to make bigger showing to have the jury exposed to it, and they were improperly exposed to it, then prejudice is absolutely inherent there. I have a question, and counsel may remember the record better than I do, but she said that there was a finding that the victim-sensitive interviews, the CAC interviews at sentencing, were relevant and reliable. I don't believe there was ever a 11510 hearing for the sentencing. I don't remember the court making that finding, that they are relevant and reliable. They weren't challenged. I think there was ineffectiveness at sentencing as well. But we limit and constrain what can be called a victim impact statement because they're so impactful. We carve out very specific things. And it makes it a little bit different than just a low-level hearsay that an officer reports that somebody else reported. The impact is high enough that we really need to walk through the proper hoops before we admit anything like that. As far as the issue regarding argument 4, I think that the state's argument's a bit off focus. We're not asking this court to vacate the 15 CF case. Our problem is that counsel was ineffective by not immediately refiling his motion to vacate that 15 CF back when it was timely. So this is a benefit of the bargain problem. The state kept the benefit of the bargain, which was this conviction stays in place, but the state also got the benefit of being able to basically have him extended term eligible. Whereas if he'd had effective advocacy, and if this court said we don't have enough evidence until we got to a post-conviction hearing, that's a possible result. But the evidence here is sufficiently of the record. We know that he wanted to withdraw it. We know that he wanted to withdraw it because it impacted the extended term eligibility. We know he had a colorable reason to withdraw it because he wasn't properly advised about that with these other pending charges. And there's no reason to think that they made a strategic decision not to withdraw the offense that made him extended term eligible. So for those reasons, again, I think that Count 1 should be vacated. This should be resentencing on all counts. And definitely there should just be a new trial on the surviving counts because that improperly admitted other crimes evidence was simply too prejudicial to ignore. Thank you very much.
I have one question.
Please.
Back to the unlawful restraint. Ms. Paige Brooks tells us this is a case about threats. There was the unaddressed fact, I believe, from your perspective, that there was the paramour checking to see throughout the night if there's some evidence to that, if I recall correctly. And so is there a reasonable apprehension of harm or force should she get caught in the act of leaving the shed? Is that something you want to address?
Well, first of all, I think that evidence is overstated. I don't believe there was evidence that he was checking at night and then a particular punishment would follow if he finds her outside of that. And I think that is really necessary.
That's twofold.
But that lack of threat is
the proposition is that he was checking to see if she was still in place in the shed. That's
Sure.
all I offer it for.
Well, I think that we need to be careful about making a criminal charge based on her subjective view of what might happen. She needs to be able to testify. I was told if I left, this would happen. There needs to be an express threat. She never did that. She never testified. We say common sense, common sense. We can't have a criminal charge hang on what's called common sense. The elements have to be laid out. The elements have to be proven. And she never testified. I was told if I left, this would happen.
Isn't there always a level of speculation with regard to having a reasonable apprehension that something could occur?
Yeah, it's definitely speculative.
Yet that's the language contained in the case law in which you and counsel cite.
Uh,
The reasonable apprehension of force.
right. Well, there needs to be a basis for that. Well, again, I don't think you can get to a reasonable apprehension of force without an express threat for the purpose of unlawful restraint. There needs to be something clearer than what was demonstrated in the case here.
Seeing no further questions, thank you, counsel.
Thank you, Your Honors.
And with that, the court will take the matter under advisement and the court will stand in recess.
Council's out of the meeting and the live stream is ended.